Hello and welcome back. Attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today we're tackling a question we often get, sometimes to an annoying degree: where's the money? Beneficiaries want to know because they want their money, and executors, administrators, and successor trustees want to know so they can move on with their lives. When the administration of either a probate estate or a trust drags on, especially with impatient beneficiaries, we often do preliminary distributions to keep everyone happy. So hit like, subscribe, share the video with anyone involved with an estate or trust administration, and let's dive in. First, let's differentiate between probate estates and trust estates. In both cases, preliminary distributions can be made to beneficiaries, and the same principles generally apply. However, there is a crucial difference when it comes to probate estates: court oversight. In probate, the entire process is overseen by the court, which means any preliminary distributions require court approval. This oversight ensures the distributions are made fairly and without jeopardizing the rights of creditors or other beneficiaries. In contrast, with trust estates, absent a provision in the trust specifically prohibiting preliminary distributions, the successor trustee has the discretion to make preliminary distributions without needing court approval. This is a significant benefit of trust administration over probate administration, as it allows for handling matters privately and efficiently. To be clear, preliminary distributions are partial distributions of the estate's assets to beneficiaries before the estate is settled. This can be particularly advantageous when the estate administration is expected to take a long time, such as over a year, or even several years due to taxes, creditor claims, or litigation. So why make preliminary distributions? Beneficiaries, especially those who are elderly or in need of funds, should not have to wait years to access their inheritance. Courts generally favor preliminary distributions as they allow beneficiaries to enjoy their inheritance sooner, provided it does not jeopardize the estate. They can also be used as a tool to placate a potentially troublesome beneficiary. Essentially, squeaky wheel gets the grease. However, if we're in that situation, we need to be careful, as we don't want the trust or probate estate to inadvertently bankroll litigation against itself. So, if you find yourself in a situation with a troublesome beneficiary, it may be prudent to instead not grease that wheel. For probate estates, remember, we have court oversight, so we need a judge to sign off on preliminary distributions before they can be made. A petition must be filed with the court and notice must be given to all interested parties. The court will then determine if the distribution can be made without harm to creditors or other beneficiaries. It's usually advantageous to file a petition after the creditor claim period is expired and uncontested claims are settled. This helps ensure that there are no outstanding claims that could jeopardize the estate. Courts are cautious about granting preliminary distributions if the petition is filed too early because of the potential for outstanding claims. At least 15 days before the hearing on the petition for preliminary distribution, notice must be served on certain designated persons who constitute heirs, interested parties, and known creditors. This notice period allows any interested parties to object to the proposed distribution. However, you should also keep in mind that since we need court approval, we are therefore on court timelines to do so. This can mean 2 to 4 months in between filing the petition that asks for the money and a judge ultimately deciding. Not a fast process in a pinch. For trust estates, the trustee can decide to make preliminary distributions at their discretion unless specifically prohibited by the trust document. This flexibility allows the trustee to act quickly and provide funds to beneficiaries in need. For preliminary distributions to be approved, the court must make specific findings of fact. The court must determine that the distribution can be made without loss to creditors or injury to the estate or any interested person, as stated in Probate Code Section 11.621. There are no express limitations on the amount of property that can be distributed under a petition for preliminary distribution, as long as the court determines that adequate protection exists for creditors and other interested parties. However, the court will require that ample funds remain for any likely obligations of the estate, such as debt to creditors, taxes, or potential litigation. A petition for preliminary distribution may be filed by any interested person who can show a direct pecuniary interest in the distribution. This typically includes heirs, beneficiaries, and sometimes creditors. Any person interested in the estate may oppose a petition for preliminary distribution. Case law has defined person interested in the estate as one who has a direct pecuniary interest, think monetary, and that would be defeated if the distribution as requested were granted. The costs of a proceeding in connection with a petition for preliminary distribution are paid by the distributee or the estate. in proportions determined by the court. This means that persons who will not necessarily benefit from the preliminary distribution may have to pay their pro rata share of the additional costs, which, while not major, can be several $1,000s in most cases. Another important aspect of trust administrations is the HEMS clause, which stands for Health, Education, Maintenance, and Support. These clauses can be found in wills, but are typically found in trusts, especially in California, where avoiding probate is a primary goal. A HEMS clause allows the trustee to use funds from the trust for a beneficiary's health, education, maintenance, and support, often until the beneficiary reaches a certain age or meets certain conditions. Now, in most circumstances, the trustee is given wide discretion to use their own judgment as to what constitutes a valid HEMS expense and whether to make that payment in the first place. Additionally, though not necessary, it is typical that the trustee is prohibited from making any distributions directly to the beneficiary until they fulfill a certain condition, such as reaching a certain age, like 25, for example. There are several benefits to a HEMS clause, the first of which should be obvious: protecting the beneficiary from themselves. If you have someone who you think may be irresponsible with money, or who you just think it would be better if that 21-year-old didn't have a sudden influx of cash, then a HEMS clause is a great way to preserve your hard-earned estate from being wasted and entrusting its management to a trusted person, and presumably they're more responsible. Next, HEMS allows for your choice of money manager by putting the trustee in charge of the funds. If one of the deciding factors as to who your trustee is going to be is their ability to manage money, then why not have them manage money that's going to be held in trust for the benefit of another over time? Where this often crops up in my practice is when grandparents have an age 25 clause with HEMS, meaning the money stays in trust until age 25, but the trustee can make HEMS distributions. Grandparents are picking backup trustees for their own children to manage the estate on behalf of beneficiary grandchildren. Sometimes they're fine with the son or daughter-in-law fulfilling that role, but oftentimes they just feel more comfortable with picking another member of the family, such as a sibling, a cousin, or a niece or nephew. That way, they pick their money manager, the trustee, and they're comfortable knowing that there's going to be something there for the grandchildren until they get older and presumably more responsible. Lastly, another great benefit of a HEMS clause is the inherent creditor protection it can bring. If your beneficiary is irresponsible with money and your trust requires their share stays in trust, then having the HEMS clause can allow your trustee to still provide for that beneficiary's needs without distributing to them directly and thus opening up that money to that beneficiary's creditors. However, if that money is given to that beneficiary either because the trustee elected to or the trust required it to be done, let's say they reach the right age, then that money will be subject to that beneficiary's creditors. So keep that in mind when speaking to your estate planning attorney. Let's look at some examples. A grandparent might set up a trust with a HEMS clause and an age restriction such as 25, but allow for distributions for college expenses or health needs before then. This ensures that the funds are available for important needs while protecting the bulk of the inheritance until the beneficiary is more mature, we'll say. Standard stuff. Nevertheless, HEMS clauses can also allow for customization. For instance, I had a client who wanted an age 30 clause for one of her grandchildren, but that grandchild was planning on going into nursing. We designed a distribution plan with an age 30 clause in HEMS, but authorized the trustee to distribute the balance of the beneficiary's share before age 30 if they acquired an undergraduate degree or a vocational license. This approach incentivizes the beneficiary to achieve educational or vocational milestones while protecting the inheritance. That was actually the first time we had done that type of customization, but since then I've done it many times for other clients because people get really excited when I bring it up as an example of the types of conditions they can do on inheritance from their estate plans. When considering preliminary distributions, trustees and executors should strive for equality and fairness to avoid disputes. Communication with beneficiaries about their wishes and any potential objections is crucial. In some cases, seeking a preliminary distribution might be considered a fiduciary duty to benefit the heirs. To bring it all together, preliminary distributions from both probate and trust estates are valuable tools for providing beneficiaries with timely access to their inheritance. Understanding the processes and considerations involved can help executors, administrators, and trustees manage these distributions effectively. But let me know, have you dealt with preliminary distributions in an estate or trust? Do you have that one family member you just know would ask for money on day one? Let me know in the comments below. Thank you for watching. Be sure to like, subscribe, and share the video with the person in charge of your inheritance. I'm attorney Andrew Bethel, and I'll see you at our next meeting.